single judge, and that is the balance of judgment that I have taken.
I'm going to pause there because I know a number of colleagues want to come in, so I'll start with Neil.
Thank you very much, Chair. Lord Chancellor, I'd like to come back to the issue of the evidence base for curtailing jury trials. Are you able to confirm whether the government currently holds empirical data demonstrating that restricting the right to trial by jury will materially reduce the backlog?
Yes, of course we do.
Okay. If that data exists, will you not only publish it but ensure that it includes all the assumptions associated with it, all the modelling and all the sensitivity analysis?
As you know, ministers have a range of data available to them. That data is being updated, it's being validated. Sir Brian himself relied on some of that data which will inform our data, and as I've said, we will publish the impact assessments alongside the bill, and I will seek to help the committee as it seeks to scrutinise that as we get to that stage in the spring.
At the risk of repeating the question, you've said you'll publish the impact assessment, but will you include within that all of the assumptions, all of the modelling and all the sensitivity analysis?
I will include, of course, the assumptions that sit behind where we've got that enables Parliament to properly scrutinise and helps people understand why the government has arrived at the position it has.
Noticed you're reluctant to use the word all. Will you produce all the analysis?
I will do what I deem appropriate for the purposes of this bill passing and to ensure parliamentary scrutiny. I've been in Parliament 25 years. I've seen a number of impact assessments, both economic and equalities. Equalities is particularly important in this area, as is the economic data that we believe will drive down the figures, and of course that will be available to the committee.
You will be aware that both the Bar Council and the Criminal Bar Association have concerns about this specific proposal. They have requested the data. Is there a reason that data has not been shared with them at this stage, given that they are such critical stakeholders?
Well, we will continue to work with the Bar Council in the usual way, as you would expect.
Do you accept their position, which is that Sir Brian, whilst it's a worthy piece of work, his recommendations have neither been piloted nor have they been modelled thoroughly? Do you accept that position that the Bar Council and the CBA have taken, or do you think they're wrong?
We asked Brian to do a very serious piece of work. He was supported by a panel. Some of that work involved modelling in other common law jurisdictions which were comparable in terms of the changes that were made. You will know also that the department publishes a lot of data. This is the department that publishes a lot of data. Recent court and prison protections were published on the 4th of December. And as I've said, I totally understand that in order to get any legislation through, it's important that Parliament is able to do the proper scrutiny, and so I want to make sure that those impact statements are sound and are thorough, and that parliamentarians are able to do their work both in this place and the other place.
There are currently in the region of 17,500 prisoners on remand in this country. Will these reforms apply retrospectively?
No.
You've also acknowledged that the proposals will not make a difference to the existing backlog in the short term. Given that that is the case, can you explain to victims, to witnesses, to defendants who are currently awaiting trial, often years in the future, why you're not looking at measures that will affect the backlog in a more expedient manner?
No, that's a misunderstanding. What I've said is that legislation takes time, and so the proposals that we have accepted that we're making in relation to Sir Brian's recommendations will, of course, can only come into effect at royal assent. But we are getting on with investing in sitting days. That is happening now, and I've increased those sitting days. When the Lord Chancellor was here last year, we were talking at 106 sitting days. I'm able, record funding now, 111,250 sitting days, over 5,000 more than the previous government funded. So sitting days are up, the investment is up. Investing in court maintenance is essential and is happening. Modernisation is key, and part of that modernisation will emanate from Brian's part 2, which we can get on with from the spring of next year. So that will be happening.
Sir Brian's report actually envisaged trials taking place with a jury and magistrates, not judges sitting. Sorry, a judge and magistrates, not judges sitting alone. How does the government reconcile that distinction with the current proposals that are being put forward?
I think Brian recognised that we might come to a different judgment, and the judgment I came to was we are giving our magistrates more power in the magistrates' court in terms of their sentencing up to 18 months, but they could go to, or the government has the power to take that to 24. I'm recruiting more magistrates at this time, and therefore on reflecting other systems, particularly the system in Canada, I settled on the single judge.
Does it not mean that the evidence base which Sir Brian has reached was based upon his hypothesis of a judge and magistrates and not on a judge sitting alone, and therefore to extrapolate that would be a false result?
That's why the honourable member rightly expects the modelling and the impact assessment in relation to the bill that we've actually come forward with, and that will be available to the committee.
That opens the question that modelling hasn't been done to date, and therefore this is a proposal that is...
It opens the question that, as I said, that the government is doing that modelling. Some of that modelling is based on where we end up with sitting days and the concordat with the Lady Chief Justice. That will be available at the point at which we publish a bill in the spring. But I will seek to do what I can in relation to this committee before that, if I can. That's the undertaking I've given.
But it is a case that the modelling is not complete at this stage, and therefore it's based on assumptions that...
Modelling is ongoing.
Do you accept that even if Sir Brian's analysis is correct and that it will lead to a 20% reduction in trial length, that would only apply to a fraction, about 3% of trials in total?
Yes.
The other issue, of course, since you've touched upon, Lord Chancellor, is the presence of advocates and having enough people going into the criminal bar. Now, we know that junior barristers don't go into the criminal bar because it pays well. They go into it because they have a passion for criminal law. Now, part of that, of course, is the thrill, if I can put it that way, of being a jury advocate. By removing those opportunities, are you concerned that that will reduce the number of individuals who will choose to go to the criminal bar when they could have a much more profitable career, perhaps in the Chancery or other areas of law?
Well, it's precisely because I'm worried about the pattern and what we're seeing with the criminal bar and indeed with criminal solicitors that I've made the investment that I have in those match-funded mini pupilages, so that we see the next generation of criminal barristers coming through. That's hugely important over this next time. And so obviously there has been some attention on changes to jury trial, but I don't think we should lose the significant investment that we're making in legal aid, the uplift in fees, and the mini pupillage scheme, match-funded scheme, to ensure that we have that next generation of lawyers coming through. I think part of your question is also, is there some disincentive almost to become a criminal barrister? Just to emphasise that trials are running longer, trials are more complex, there will be a significant number of jury trials and indeed patterns in terms of more serious cases would suggest that there will still be a lot of jury trials, so there will be quite enough work to go around.
Has your department undertaken any analysis of the impact that changes to the jury system will have on retention, particularly at the junior end of the bar?
Sorry?
Has your department done any analysis as to the impact of the proposed changes to jury trial on the retention of the junior end of the bar?
Both the analysis that the Criminal Bar Association has done, the Bar Council have done, and the department has done on workforce informs the decisions that we've been made about mini pupilages, precisely to deal with some of the retention issues. And I should just say that following our reforms, it's still the case that around 3/4 of trials in the Crown Court will continue to be heard by a jury.
That's a slightly different answer. That's about the wider retention issue of the criminal bar. I'm asking specifically about your proposed changes to jury trials. Have you done any analysis on that?
And as I've indicated, of course we've done analysis. That is why we are putting money from taxpayers into a match-funded system to increase the number of junior barristers. Of course, what sits behind that is analysis and trends that we're seeing in the criminal bar.
Grateful, Chair.
I'm going to be Ricky Slay, but just